Hi, hello to everybody. This is the international online discussion, The Work of Lawyers in Crimea and Russia Who Will Defend the Defenders. Today we have the International Day of Endangered Lawyer, which this year is focusing on Azerbaijan, but it's important to highlight. So today we set up the online discussion among the professionals and legal community, and we will look also on what's going on, but as well we'll search out for the ways for the solidarity. My name is Natalia Gumenyuk. I'm a Ukrainian journalist, reporter. I worked extensively in the occupied Crimea, and I'm honored to moderate discussion. Among our guests, there will be Lilya Gemeji, who is a lawyer from the occupied Crimea. She represents the interest of many people against whom the criminal cases on religious ground had been fabricated. We will talk to Vyacheslav Romanov, a Russian lawyer who has been engaged for years in the expertise in the field of the information transparency. And he also manages the media project Advocacy. Also, Dr. Ludmila Ulyashina is Associate Professor, Head of the International and EU Law Program Committee at the European Humanities University in Vilnius. And we're very glad that Stephen Townley, the Legal Director of the Clooney Foundation for Justice TrialWatch initiative, will join us. I'll speak a bit more about him. And I would warn you that later, exactly in 1 hour, we will have not just an address to our discussion. There would be joined Stefano Sensi. He's a human rights officer at the United Nations Office of the High Commissioner for the Human Rights. And now there are some technicalities. The discussion is bilingual. The event can be viewed at this concrete time on the website of the Ukrainian Crisis Media Center by the links we have in the chat at this Zoom. So if you look at the chat, you will see the link. So I will probably say it as well in Russian. Для тех, кто слушает нас на русском языке и
I would like to repeat the same in Russian. If you do not have good command in English, you may watch us in Russian language. You may find the link in chat. The link is to the Russian-speaking channel. Some of our speakers will make their interventions in Russian, but the majority will be in English.
Housekeeping remark. Our discussion is bilingual. There are speakers who are speaking in Russian and speakers who are speaking in English. I will ask my questions in English. For this, we have on the webpage of the Ukrainian Crisis Center bilingual translation in English and in Russian. Who wants to watch original, please stay in Zoom. The address is quite lengthy, so you can just follow those links. I also encourage everybody to ask your questions politely in the chat. We will have some time closer to the end of the discussion to address more of your questions, but I would probably ask everybody to send your questions right away, so they will also be helpful for our discussion. And very important, of course, I want to thank the organizers of this event. This is the Center for the Civic Liberties Ukraine, the Moscow Helsinki Group from Russia, Lawyers for Lawyers from the Netherlands, American Bar Association's Rule of Law Initiative, and the Association of the Ukrainian Lawyers. So I think a lot of people helped us to set up, and here we are, and we in fact can start because we will start with Lilya Gemeji. I want to add that it's true that the professional activities of lawyers in the occupied Crimea and Russia are associated with severe risk. Lawyers undergo pressure, intimidation, threat due to their professional activities, especially when dealing with sensitive political issues. And there are a lot of risk. So in order to kick off of this discussion, I would ask my questions to Lilya, who is probably now in the most volatile place she is based in Crimea now, and probably from the ground, Lilya will be ready to say and explain what's going on there and what are the issues in particular connected to the security of the human rights defenders. Lilya, вам слово. Lilya was with us. I've just talked to her. So let's wait for one moment. And if not, sorry for the, the Lilya was with us just one. Lilya, yes, I see you. Lilya, please unmute yourself. Lilya, пожалуйста, включите звук, и мы...
Please unmute yourself. We are ready to.
Прошу прощения, сегодня у нас...
I have to apologize. Unfortunately, the sound has been interrupted.
Everything, sorry for it's technical. I said like a couple of minutes ago we could perfectly hear what Lilya was saying. I want to give also another word to kicking on this discussion to Vyacheslav Romanov, who since 2012 been engaged in expertise in the field of information transparency of state authorities and local governments, and cooperates with the human rights organization like Team 29 and Prague Club. So, and maybe we don't know enough what is the life of the human rights defenders in Russia, especially outside of Moscow. So please, I'll be happy to give a floor to Vyacheslav. You can start.
Natalia, спасибо.
Thank you. I would like to thank once again for this invitation. Here I'm present as a leader of the Lawyers' Voice project. This is an open platform where we provide an opportunity for lawyers to present about violation of their rights. Unfortunately, we have such cases in Russia when lawyers are persecuted. We believe that the lawyers community have to develop their joint position and bring it to attention of the lawyers and to the attention of international community. And 3 years in a row, we have been doing that on different, from the on behalf of different lawyers organizations in Russia. More and more lawyers community is involved to the general awareness about violation of the lawyers' rights, the rights of those lawyers who advocate for the human rights. We would like to thank the Lawyers for their support in this field. Unfortunately, at the previous event, some presenters, the lawyers, had become the figures under investigation or under persecution. For example, the lawyers of Irina Danilova were charged in fraud and because the investigators believe that she was excessively paid for her professional work, and the search in her office was done in her absence, and the procedure of claim to court, when she claimed to court for legal procedure, this was denied. Then the Moscow lawyers chamber filed its claim to the prosecutor in Moscow, etc. The lawyer, Degir Asarov, who defended in court the officials from Dagestan, it was charged with criminal charges, and he was brought to the preliminary jail, and unfortunately the court hearings had been being delayed several times. The lawyers, his lawyers, were not provided with sufficient time to review the case, and also he was excluded from the list of lawyers. Also, we have several lawyers in human rights activist cases who are charged with bribery, and their telephone talks were intercepted, recorded, and all that cases show all the signs that the procedure of investigation and persecution is violated. Also, the lawyers are charged with the abuse of official cases, also the interference into the preliminary investigation. Quite often the telephones of lawyers are intercepted, and then they are charged with the violations of the investigation procedure claims, and actually although that is not what they do, it is absolutely illegal. Quite often the human rights lawyers also face insufficient time allocated for reading the files. Then the lawyers who are duplicating their activity. Quite often lawyers are prevented from attendance of their clients in jails, etc. Independent lawyers associations try to submit this information to the international lawyers and associations.
Defend the lawyers. And I want to finally give a word to Lilya Gemeji, who represent the Crimean Solidarity Initiative, which monitor court hearings, record violation during searches, and support the families of political prisoners in the occupied Crimea. So, Lilya, let us explain what's really going on with the human rights defenders in Crimea today. Who are behind the bars? We especially know that it's becoming even way more difficult because of the COVID pandemics, the access to the people who are behind the bars, including the lawyers. Please, the floor is yours. A bit struggling because as I've
Наталья.
Да.
Алло, слышно меня?
Yes, now, да, Лилия. Lilya with us.
Прошу прощения, проблемы со светом. У нас сегодня отключили свет.
So, Lilya,
The electricity is interrupted.
energy, so they didn't have the energy in the house. So let's see, it will probably work like later. And I probably then will give the floor now to Stephen Townley, who is the legal director of the Clooney Foundation for Justice TrialWatch initiative. To those who doesn't know, TrialWatch monitors trials of journalists, women, LGBTQ persons, minorities, and human rights defenders and advocates for
Наталья,
unjustly
меня слышно?
imprisoned individuals. And Stephen was previously served as a deputy legal advisor of the U.S. mission to the UN in New York. There is quite a lengthy bio of Stephen, but I will have the concrete question. First of all, your initiative is international. You in particular work in the countries where we might not trust the independence of courts, and courts are used to pressure the people. But how effective your monitoring is? What can you do apart from documenting that the rights of the rights of the people are violated?
Thank you very much, and thank you again for the invitation. Let me perhaps start by emphasizing that our trial monitoring is meant to drive advocacy. So we don't just document what happens in courts, but we want to use it to pursue remedies. So that could be by helping to take a case to an international, regional, or domestic body, or in other cases, the reports on trials we monitor can be used by a defendant to support their own appeal. And maybe let me say a little bit of a word about what trial monitoring is and sort of how it can help, which is, so trial monitoring involves sending an observer into court to report what they see and what they hear. And I think there are two phenomena that we've already heard, maybe even three phenomena that we've already even heard discussed. One is where a lawyer is criminally charged, separate from a particular representation, but where there's a concern that the charge may be because of their work defending human rights defenders. And in that case, trial monitoring can first help by making clear to the court and other actors that an independent monitor and the wider public are watching and expecting them to meet their obligations to ensure a fair trial. But also specifically, it can help by a careful review of what the evidence was, what the arguments made in court were. It can help to check whether in fact there is a proper predicate for the charges, or whether there is merit to the concern that the charges were politicized. There are, of course, provisions, for instance, in the European Convention on Human Rights that forbid prosecutions for ulterior motives. So one thing trial monitoring can help to do is detect where a case may be being brought against a lawyer, not because of a well-founded belief that they have committed criminal conduct, but in retaliation for their legal work. There's another phenomenon that we see, which is lawyers who, and perhaps this is what colleagues were referring to with respect to interference in cases, but we sometimes see lawyers prosecuted for speaking out about their concerns about the judiciary. And sometimes they can get put on trial for different offenses. It could be defamation or criticism of the judiciary, insulting the judiciary, undermining confidence in the judiciary. And again, trial monitoring, if those cases proceed, can help to check whether, in fact, the prosecution violates the right to freedom of expression that the lawyer has, which allows them to express their views about the legal process on which they are already an expert. The last thing I'll say, because I want to keep my introductory remarks here short, is colleagues referred to the limits that lawyers may face at trial in terms of time to review documents or ability to present arguments. And this is also something where trial monitoring can be helpful. Trial monitoring can pick those up and provide an impartial report of whether a lawyer's arguments were given a proper hearing by the court, whether they had time to prepare, and on that basis, conduct a legal analysis to help assess whether the defendant's rights in that case were violated. In fact, where there are international standards governing where a defense team is not, where the court does not consider key defense arguments, that it can show violations of the defendant's right to be presumed innocent, or right to be tried by an impartial court, or in some cases, right to call and examine witnesses. So in each of these circumstances, trial monitoring provides an impartial record of what happens, shines a light on what happens, allows analysis of whether a lawyer's prosecution or treatment is grounded or not. And then where it's not, facilitates advocacy, because you can take that record and submit it to a court of appeal. You can take that record and bring it to the attention of the international community or international or regional human rights mechanisms. I'll stop there. Happy to go into any of that in greater detail or speak to some of the experiences we've had in the region as appropriate.
Okay, thanks a lot. And Lyudmila, probably that's time to ask you. I want to introduce again Dr. Ludmila Ulyashina, who is Associate Professor, Head of International and EU Law Program Committee at the European Humanities University in Vilnius. Lyudmila is also the author of the idea and the expert of the program for lawyers of the Network of Human Rights Houses. Lyudmila, we want to already get into the solutions. To what extent the international community can help, what we really can do to support the lawyers, especially in the countries where they are under the pressure, and maybe give us a short assessment. Is the situation becoming, let's say, a bit worse? Especially in the countries like Russia or other countries in Eastern Europe, the government care less about the independence of law, and the international leverage isn't really working, the pressure to make their court independent? Lyudmila, also switch on your mic. Yeah.
Thank you very much for this invitation. I was asked to speak about the international standards, and also the question was voiced about what international community may do in order to help the lawyers who work in the area of human rights at the national level. It is worth saying that the problem of the lawyers and the protection of lawyers is related with the concept of human rights, and it may work only in case if human rights can be protected in the courts. And This protection started in the post-Soviet region, and the European Convention on Human Rights was ratified and accepted, and the Pact on Civil and Political Rights and the protocol were implemented. They are not only declarative. And starting this moment, we have seen that the lawyers, the activity of which was regulated by the national legislation, by the national governments, these lawyers need protection. In 1990, first standards, universal standards were adopted concerning the lawyers. This document has not been implemented for a long time, and now this is an important document, and this resolution of the conference includes all necessary provisions that outline all the rights of the lawyers and the role the professional organization should play and the responsibilities that are within the power of the state in order that the lawyers be able to implement their functions freely and professionally without interruption of their professional activity. And the situation with the lawyers becomes worse and worse because the number of cases concerning their rights, the situation deteriorates, and the lawyer protects not only the party in the case, but often the party that files the case against the state or institutions, state institutions, and international law and international institutions, they should intervene. And the lawyers, they also create associations, independent associations, they help each other in order to become stronger and to provide for solidarity and support. I would like to briefly say now that we have a program or initiative that have been in place for more than 15 years. This is for the international law advocacy. It includes several countries, including Azerbaijan, Ukraine, Russia, Moldova, Georgia, Belarus. And the lawyers of these countries who had the opportunity to be trained in the online program on human rights, they now discuss these issues. They have been doing it for 10 years. At least they identify new problems and challenges for the lawyers, and they prepare, they are trained how to prepare reports, and they have consultations with international organizations in order to clarify and identify more precisely the role and the opportunities that can be used by international bodies, including professional international organizations, in order to help the lawyers. And moreover, the lawyers themselves, they support each other, and professional associations of the countries send their letters of concern to the colleagues and professional associations of the countries where their colleagues work. I cannot say that this is really efficient, but it helps to increase the feeling of solidarity and that we are standing shoulder to shoulder. And about international organizations, I would like to focus on this now. And we have such a good instrument that was prepared by the Institute of Human Rights of the International Associations of Lawyers. It consists of international legal digest that is called Lawyers Protection State Obligation. So it means that lawyers are protected and the state is obliged to do this. And three special modules that identify the international standards, and also they teach how to identify the main risks and how to reduce those risks. And these toolkits, they are available on the website of the organization, and I would recommend them to our colleagues in order that they be able to use them in their practical work. This is all from me. Now we will give the floor to Lilya.
Electricity in the house. I just want everybody, if you have the questions, be ready to write them down in the chat. Лиля, начинайте.
Lilya, you may start. Good afternoon. I greet everyone who joined us today in this discussion. I thank you for the opportunity to speak today. I would like to go outside the framework of this discussion and to speak not only about the protection of lawyers, but also about the protection of those people who also protect the rights of those who are illegally persecuted. These are human rights defenders, public defenders. In Crimea, we have a lot of people like this. And there is a negative trend of persecution against human rights defenders, and we should elaborate efficient mechanisms of protection. And in professional community, there is an increasing conviction that this human rights, they should be properly protected, and proper information should be provided to the media, to international community. The violations should be recorded and reported, and this will provide grounds for further work. And persecution of defenders, it goes in several areas, and the first I would like to point out is information war. For these purposes, they involve affiliated to the government mass media, and defenders are associated with the people they protect, they defend. One of the examples is the case of Emil Kurbedinov. On one of the channels, he was called the devil's advocate. And when he is defending people, these people are asked to reject him. And the motivation is that such a lawyer as Emil Kurbedinov or other defender, they only will bring more punishment, and the sentence will be longer for this person because of this lawyer. And they propose the lawyer that is under control of the government. And also, lawyers complained about the lawyers and the complaints they send. These complaints are against independent lawyers and human rights defenders. And in Crimea, for example, these are the lawyers who deal with Crimea cases. Such trend is not a new one. And also, Taras Amirchenko case, he was the defender in the case of 26th of February, and Taras and other colleagues with whom I participated in the second OHCHR group, we got also warnings from the judge, and me as a defender, I also got a warning that was sent to the chamber. And before I got this warning, my defendant was several times brought out of the process. He was limited in his rights to be protected. And this warning against me was a cooling effect on me and on my colleagues, and the court was trying to reduce our activity and our opposition to those legal actions that happened during the court hearing. And the lawyers association, they try to provide fair decisions, and they support the lawyers. And in one of the lawyers' papers, there was a resolution. There was a decision of the Court of Moscow Oblast that didn't find the violations in the activity of the lawyer, and they explained the lawyer's behavior as that this behavior was provoked by the judge, and they were called Allegoric, and this I would like to say several words about the case. When this warning was provided against me in the second Vyacheslav case. This is a case that includes 8 people. One of them was found not guilty, and 8 people. These were people with active civic position, journalists, volunteers. One of them, well known in Crimea, Server Mustafayev. And Server Mustafayev, he is one of the participants of this case. He is in isolation since 2018, and he is behind bars because of his activity as his human rights defenders activity. He recorded violations in courts, and he supported the families of people, and he got the sentence in the colony of the with the rigid regime, and there was some people in the mosque. They were speaking in Bakhchisarai. They were speaking and praying, and he provided a comment for 2 minutes, and the witness that was in. One person presented the evidence during the hearings, and there were many concerns about the psychological condition of this witness. Even he said that he didn't provide evidence that my defendant was involved in some illegal activity. The third aspect, how they pressure the lawyers. These are searches, criminal and administrative persecutions and detentions. It is worth noting that in the office and at home of Emil Kurbedinov, they had some searches. During these searches, these searches were done without representative of the lawyer's chamber. They seized a lot of equipment that included the lawyer's secret, 7 notebooks, tablets, and also flash memory devices that included the advocate's secret. And also there were searches, and they were not grounded. Nikolai Polozov was detained, and this was politically motivated case in January 2017. Also, he was interrogated as a witness, and he was brought out of this case concerning Lyudmila, and this is administrative detention of my colleague, an administrative arrest of Emil Kurbedinov in 2017 and 2019, and the last detention, an administrative punishment, and also my colleague was deprived of his status, and also there were searches in at the house of Demsemilev and also Mametov. There were threats from law enforcement bodies. They wanted to start the criminal case against him, and also the threats to Emil Kurbedinov. And also there is a new trend that started in Crimea. This is detention of women. May 2019, 2 lawyers were detained Mumia Tsalieva, Ulufia Zudieva, they were put in the car in those cities where they live, Bakhchisarai and Jankoy, and they were brought to the center of extremism counteraction, and they were detained there without a lawyer. And I was a lawyer, and Minko Vedinov also joined us, and they were detained there for several hours. And Lutfia and Rufia, they have 4 underage children, and also there is the law envisages that if a person has a woman has a child under 14, they cannot be detained like this. And also Lufia actively participates actively in administrative processes, and this is allowed without the status of the lawyer. Lilya? We will have time to speak about this, what can be done. So maybe I will provide another piece of information later on.
Next session. In fact, right now, I want everybody from our speakers maybe to think that we see that the just legal defense doesn't really work. So what maybe can be the unconventional ways, in new ways, what can be the innovation of this support and solidarity? So for instance, Vyacheslav, Lyudmila, but probably I would address again to Stephen. You're trying to use some IT, high-tech solutions with your apps, for instance, in the TrialWatch. So you listen now, for instance, to Vyacheslav or Lilya. What kind of your expertise from other places where the things are really bad can be brought and known?
Sure, thank you. And I do think that there are some lessons or ideas we might be able to bring to bear. And in fact, we've been monitoring some trials in Russia and coming out of Crimea already in terms of defendants who've been, as Lilya knows, taken from Crimea and tried in Russia. But I think one of the ideas we have about trial monitoring is that it should be more widespread, that the more we're able to shine a light on the phenomena that colleagues are describing, the more pressure can be brought to bear to remedy violations. The more we can document, the more particular cases can be brought before the international and regional bodies. And so, at least with TrialWatch, we seek to work with local monitors in order to expand our ability to monitor and, of course, foster local ownership of solutions. We don't require that monitors be lawyers. Our approach is to say the monitor will gather the facts, and then a legal analysis can be done separately. So again, the idea there is to allow a much bigger pool of individuals to serve as court monitors by not requiring that monitors be lawyers. And we do, as you say, use technology to try to guide and assist monitors in gathering what they need. Again, with a view to capacitating a broader group of individuals who can be monitors, whether that's journalists, whether that's law students, whether that's just persons in the community who want to see whether justice is being done or not. The idea is to get more information so that we can shine a light on violations that occur. And I do think our experience has been that where you're able to gather that kind of information, it can help to assess whether or not there was a factual predicate to action that's being taken against a lawyer. So Lilya speaks about warnings in courts, whether whether judges are appropriately responding to the conduct of lawyers. And again, that's where if you have an impartial observer there, separate from the transcript or protocol that may be created by the court, that impartial observer can help you see, was this fair or not? Was this appropriate or not? So I think for us, it's really two parts to the idea of the solution here, which is to get more eyes into more courtrooms, in more places, who report what happens. And then the second part is to use that information as an impartial record of what's happened to drive advocacy against unfairness.
I would pass the word to you. That's what Stephen just told. Do you think it's applicable? How helpful that kind of things would be? And maybe also what is your experience and the ideas about the possible solutions which would be efficient in Russia and in the region at large?
Спасибо за вопрос.
Thank you very much for this question. I would fully agree with Stephen that expansion and extension of this independent monitoring is a good solution to prevent pressure violations in the proceedings. This is a good way to observe the arguments which are accepted or denied by the court. But when we speak particularly about the Russian judiciary system, I would like to point out that the majority of evidence is collected before arrival of the case to court. And many risks related to those evidence, they appear long before the filing of this case to court. And that's why the lawyers should act at earlier stage, because when the case arrives to court, the chances for the defense for stronger position, they drop considerably. The next is that the lawyers have to be very careful in terms of their personal security, informational security. They should be aware about intercepts, about the possibility that all the talks, all the correspondence might be intercepted, and that they are personally under threat, that at any moment they face criminal charges. Some chambers in Russia, like the Moscow Chamber of Lawyers, allowed their members to reject from signing the a sort of papers. Quite a big pressure in Russia is made via deprival of lawyers from their solicitors' status. of course, partially this problem could be resolved via special trainings for lawyers, how to protect themselves in advance against the illegal charges, to protect themselves against interceptions, etc. So we have to be very inventive here.
How we can go for the solutions, and what probably can be the ways in this very unhealthy global environment to support the defenders as well. How what Stephen said is resonating to you?
Простите, у меня накладываются звуки.
Sorry, there was an overlaying of sounds and I was unable to hear neither Russian nor English. But nevertheless, I guess what the question was. And I would like to join this discussion, how to defend the defender, so to say. From the very beginning, we have to decide what are the immediate consequences, what are the midterm consequences, and what the long-term consequences may be. I may recollect one case when a lawyer was deprived from his lawyer's license, and that court proceedings were attended by independent monitor from Belarus with official letter from the international program, as Stephen described it, and the letter, that official letter, made a big effect immediately. The judge followed the rules very strictly, and the request to deprive the defensive lawyer from his barrister license was denied by court. So in this case, even the presence of a monitor allowed that court proceedings to become more just, better, etc. So this shows that the immediate effects be quite considerable. If we think about middle-term perspective, long-term perspective, again, we come to understanding that the lawyers have to think about that perspectives in advance. That is, those lawyers who manage to present their claim before the European Court of Human Rights, they succeeded, and now we know that the cases of Intigam, Bejiv, and Mr. Ali, that they will play their role, and unfortunately, those lawyers, they reached success in the European court, but they were rejected to become members of the local barrister associations, and this confirmed that success in the international court. I agree with the Vyacheslav's statement about ethical, moral standards of the lawyers. The role of a lawyer in judicial system is unique. On the one hand, he or she represents the interests of a client. On the other hand, she stands for the just procedure, for the fair court. And this dual position sometimes prevents the lawyer from defending her security, so to say. Quite often, lawyers are brought to responsibility for some minor things like improper documentation of something or improper doing some minor things, and in result of that, disciplinary punishment quite often is imposed. That could be prevented only when a lawyer, from the very, very early stage of the case, takes very strict ethical and professional, ethical and professional position. And the last but not least, when there are statements made, the statements expressed by lawyers associations where they protect members of the lawyers associations and present the documents produced by more independent monitors and stand for the high professional standards and demonstrate that they are ready to protect the colleagues. Supporting individual lawyers, we are able to shape the behavior models for those associations, lawyers associations, who are now at the early stages of their development. Professional lawyers associations are able to become true defenders of the lawyers in those countries where the lawyer's profession is now on the way of development.
Solutions and what Stephen told you is working. We are also already we will have Stefano Sensi from the OHCHR to join very soon, so I'll probably ask you to be rather brief.
Спасибо большое. Я буду...
Thank you so much. I would try to speak very briefly. I listened very attentively to what my colleagues mentioned, and I agree that the ways described by Vyacheslav could be effective by the moment when a lawyer is persecuted. From the moment when the persecution and pressure upon a lawyer begins, then from this very moment the response and reaction of colleagues becomes very important. And in this sense, you need support and reaction of your compatriots and of your foreign colleagues. Several times we observed that solidarity and support of colleagues from international lawyers associations or from lawyers associations in neighboring countries becomes very useful.
Already Stefano Sensi, as I've been in touch with him. Yes, I do see. Please, Stefano, switch on your mic. Stefano Sensi is a human rights officer at the United Nations Office of the High Commission for Human Rights, and currently works in the Special Procedures branch where he provides support to the mandate of the Special Rapporteur on the independence of judges and lawyers. There is a lengthy bio of Stefano, however, you can find it online. But Stefano, for this hour, we were discussing that we see in many places from the occupied Crimea to Russia, but also other regions, that the situation for the human rights defenders and the lawyers is getting worse. There is a lesser legal ways to defend themselves. Sometimes the states are using legal system to put pressure on them. Do you see that this is a correct observation according to your monitoring? And what can be really maybe new ways and on pressuring the states to fulfill what they need to fulfill, especially in the environment where they are not very, many countries and many governments, oppressive governments, stop to care about what international community thinks? You can unmute yourself and it will work. Please unmute yourself.
Here I am. Hi, my name is Stefano Sensi, and I'm a human rights officer at the Office of the High Commission for Human Rights. And I support the mandate of the Special Rapporteur on the independence of judges and lawyers. The mandate was established in 1994. It is one of the first mandates ever established by the then Commission on Human Rights. And the aim of the mandate is to elaborate on international and regional standards aimed at protecting judges, prosecutors, and lawyers against threats that may be coming from either state actors or non-state actors. With a specific regard to lawyers, the role of the Special Rapporteur consists in three different activities. The Special Rapporteur presents reports to political bodies like the General Assembly and the Human Rights Council. And some of these reports have been devoted in the past to the measures that states have to put in place to guarantee the safety and security of lawyers. The Special Rapporteur may also act on individual cases or more general issues through the so-called communication procedures. And over the years, the mandate has sent a significant number of communications to state to denounce attacks against lawyers and restrictions to the free and independent exercise of the legal profession. When addressing these communications to governments, the Special Rapporteur relies on international and regional standards that require states to adopt all appropriate measures to defend lawyers and to enable them to exercise the legal profession without any threat, intimidation, or interference, be it from state actors or non-state actors. The standards are enshrined in the first place in the International Covenants on Civil and Political Rights, and in particular, its Article 14. Article 14 lists the minimum procedural guarantees that any person charged with a criminal offense has the right to. And this includes the right to be represented by a lawyer of one's choice and the right to have adequate time and facilities to consult the lawyer and prepare one's defense. And these principles are elaborated in greater details in the basic principles on the role of lawyers. The principles were adopted in 1990 and represent to date the most comprehensive international instrument for the safeguard of the right of access to legal assistance and for the protection of the independent functioning of lawyers. We have been discussing the issue of what to do in order to provide better protection to lawyers. The basic principles contain two basic standards in this regard. Principle 16 provides that government should adopt all adequate measures to ensure that lawyers are able to perform their professional functions without intimidation, hindrance, harassment, or improper interference. And point out that lawyers should not suffer or be threatened with prosecution or civil or disciplinary action for actions they have undertaken in accordance with recognized standards of professional conduct. The principles also provide that when lawyers are threatened as a result of discharging their functions, they should be adequately safeguarded by the national authorities. In the specific case of Ukraine and the occupied territories of Crimea, in particular, the jurisprudence of the Special Rapporteur has highlighted specific threats that lawyers are exposed to in the exercise of their professional function. And this is so in particular with lawyers that deal with politically sensitive cases or represent political actors. Such lawyers, based on our experience, have been exposed to threats and intimidation that come both from national authorities, for example, the prosecution service and the judiciary, or from non-state actors, for example, civil society activists. And intimidation and threats they are exposed to are directly related to the legal service they provide in defense of the victim, in violation of a general principle that prohibits the identification of lawyers with their clients or their client causes. In many cases, lawyers have been subject to criminal or disciplinary proceedings for statements they've made in good faith in written or oral pleadings or in their appearances before the court. And this constitutes a violation of the principle that lawyers should enjoy civil and penal immunity for a statement made in good faith in the exercise of their legal profession. I see that Lilya would like to ask a question, and I would like to take this question.
Yes, yes. Use this as an opportunity, and I will help to translate in case. Stefano, in case I will write down this question in case you hear it poorly. Lilya, you can start.
Да, спасибо.
Thank you for this unique opportunity. I have a rather broad question, which is in two parts. The first part of this question is as follows. How many cases from Crimea have you received as a special rapporteur from lawyers in Crimea? And the second part of the question, what aspects of the cases should be considered or should be presented to a special rapporteur in order to resolve this case better?
How many complaints from Crimea you have from lawyers? And
Okay, thank you. We have received a few submissions from lawyers residing in Crimea. The first difficulty we encounter in these cases is that we need to address the complaint to the de facto Russian authorities because they exercise jurisdiction in the territory of Crimea. The communication is also sent to the permanent mission of Ukraine for information. But GA resolutions prevent us from addressing the communication directly to Ukraine, because it is the Russian authorities that exercise jurisdiction on lawyers. These communication usually are about disbarment or threatened disbarment of lawyers. And the disbarment is decided by the authorities of the bar association in relation to the alleged professional misconduct that has been made by the lawyer in the exercise of his or her functions. In general terms, with regard to the second question, what we need from the complainant in order to address the communication to the national authorities is a very short summary of what happened, of the facts of the case in chronological order. And general information about the lawyer, the field of expertise, and the authorities that have taken the adverse decision that affect the exercise of the legal functions. There is the websites of the special procedures contain information on how to submit complaints to special procedures. And I will now send you the link through the chat, so that you know how to submit these complaints to special procedures mandate holders. One very important thing is that we cannot proceed without the consent of the victim. For this reason, we have drafted a consent form that is available in all official languages of the UN, including Russian. Only after receiving the consent form duly signed by the victim can we take action and send a communication to national authorities. you can also send communication to the special rapporteur or to other special rapporteurs through the OHCHR monitoring mission in Ukraine. Or you may also wish to use the International Bar Association Human Rights Initiative, or other international NGOs that work on Ukraine or in Ukraine. For example, the International Commission of Jurists or the Bar Association of England and Wales, the Law Society of England and Wales. The most important things for us are to have a brief descriptions of the facts in chronological order and the consent of the victim or their relatives or legal representatives.
Stefano, thank you. There would be another question from Vyacheslav, which I'm now writing to you. It takes a bit time. So before, I want to Stephen to ask the question from our chat on in which occasions I also had written it in direct message just in case. So in which case the independent expert can be heard, and what is their position, what can be attitude towards them, especially, or can they be just protected during the public trials? I have written this question to you in your chat.
Got it. Thank you. Let me see if I've properly understood it. If the question is how to protect a monitor of court proceedings and whether they can be heard in court, is that the gist of the question?
Yes. Yeah.
Thank you. Sure. So let me take those one at a time. In general, monitors are our monitors. We want to be neutral observers so that their impartial reports on what happens is not called into question. So monitors would not participate at the time in the court proceedings. Instead, they would record what they see and what they hear, and thereafter, then an analysis could be done as to whether what they saw was fair or not. And this also offers the monitor some measure of protection itself, in that they are there to observe. Of course, then on the basis of what they see and what they hear, yes, we or others can make our views known to the court. So for instance, in some cases, what we have done is after a first instance trial that has been monitored and where there have been violations, we can submit a friend of the court brief to the appellate court saying, look what the monitor saw in the trial court. You need to remedy these violations. And we've done that in a number of jurisdictions on the basis of what the monitor saw and then a subsequent assessment of whether what happened was fair.
Okay. We have very fast. Vyacheslav, address your questions to Mr. Stefano Sensi. And Mr. Sensi, I would ask you to be very short because we have like 6 minutes till the end of the discussion. I've sent the written version of the question as well.
Yes, I got the question. So,
but like, let us, Vyacheslav, tell it aloud for our audience.
Okay.
Спасибо, Наталья. Очень коротко.
Thank you, Natalia. Recently, in relation to the events in Belarus, our colleagues prepared a big communication, big submission to the co-rapporteur. When we can apply for the co-rapporteur's advice or assessment, opinion from co-rapporteur, and communication to the Belarus government, may the co-rapporteur request for a visit to a country in order to observe the situation, and what initiatives we may undertake to protect the lawyers, because not all the things could be done by national bar associations. Some actions may be done by, or some submissions could be done by independent associations of lawyers, etc. So whether there are chances to do like that or no?
The information we receive from lawyers can be used in different ways. In particular, the communications can be used for the preparation of annual reports to political bodies, to the General Assembly and to the Human Rights Council. And the two reports that we have submitted in recent years on the protection of lawyers are based in Australia on information we have received from individual lawyers or from national bar association. When there is a pattern of violation of the rights of lawyers, or a pattern of interference with the free and independent exercise of the legal profession, these can be used in order to request a visit from the special rapporteur to the country concerned, visits that can only be carried out with the agreement of the country. In other words, the special rapporteur cannot visit the country on an official visit without the consent of the country. This does not prevent, however, the special rapporteur or his team based in Geneva to visit the country in order to participate in professional discussions, in seminars, or in academic meetings. And we have done this a lot in the past. We have intervened in meetings organized at the national level by the Bar Association. For example, I participated in a meeting organized by the Ukrainian Bar Association. The only difference in this case is that we do not issue the report on the country situation. From our visit, from our visit to Ukraine, we started to interact with the National Bar Association there, and we have been asked to make comments on a proposed law that's aimed at regulating the legal profession in Ukraine. The law presented lots of problems with regard to compliance with international standards related to the exercise of the profession. And as a result, the Ukrainian government decided to retire the law, which was not then translated into a proper law. With regard to the last question, yes, we can receive complaints not only from independent lawyers, but also from bar associations or other organizations of lawyers. But if the case relates to an individual situation, we always need the consent of the alleged victim.
Okay, thank you for addressing these questions. There was no way we didn't use this opportunity, so the colleagues can, write to ask the questions which are really important for many. I thank everybody who listened to us. For the audience, I think now the experts, especially if you're professionalists, to whom you can also address the different questions. And thanks a lot to Lilya, who joined us from the occupied Crimea, and to Vyacheslav, and to Ludmila, and to Stefan Townley. We really hope that your knowledge about your activity would be more popular and known in Eastern Europe, where maybe not many people were aware of how exactly you work, and as well to Mr. Sensi for joining us. I also want to thank the organizers, and these were the Center for the Civic Liberties from Ukraine, the Moscow Helsinki Group from Russia, Lawyers for Lawyers, the Netherlands, American Bar Association's Rule of Law Initiative from the US, and the Association of the Ukrainian Lawyers. So that would be the recording of this discussion. It's professionals, but extremely important. My name is Natalia Gumenyuk. I'm Ukrainian journalist and author. Was glad to facilitate this talk, and thank you again for devoting an hour and a half for such an important issue.